Imagine standing in line to register to vote. You have carved out an hour from your busy day. You finally make it to the front of the line, feeling, quite good about doing your civic duty.
Yeah, you're doing your part.
Exactly. But suddenly, the clerk shakes their head and turns you away. The reason? You didn't bring your physical passport or, like, an original copy of your birth certificate.
Which, I mean, on the surface, that might sound like a simple, easily corrected oversight, right?
Right. But then you look at the raw data and realize that 5 to 7% of Americans do not even own those specific documents.
Yeah, and translating those percentages into actual populations, it gives you a staggering figure. We are talking about millions of eligible native-born voters who could simply be shut out of the democratic process overnight.
Just because of an administrative technicality. And that exact scenario is the absolute center of today's deep dive. We are exploring the explosive national clash over documentary proof of citizenship, or DPOC, for voter registration.
But before we get into the weeds, I think we need to put a very important disclaimer out there for you.
Yes, definitely. Today's sources contain some highly politically charged viewpoints from across the entire political aisle.
Right. I mean, we have legal filings from Elias Law and data from the Brennan Center sitting right alongside investigative reporting from Fox News and the text of the Republican-backed SV Act.
And as your guides on this deep dive, we are absolutely impartial. We are not endorsing any political viewpoints from the left or the right. We are simply here to convey the fascinating legal, constitutional, and practical ideas contained in the original source material.
Exactly. Our mission is to basically separate the partisan rhetoric from the mechanical reality and really examine how these systems actually function in the real world.
Please like, subscribe, follow, and turn on notifications so you always know when new content is released.
As a quick update, we continue to monitor the Martin Stevens v. OpenAI matter. It is important to note that this is still not a lawsuit. Martin Stevens has suspended his voluntary quiet period after OpenAI filed its confidential S-1 registration statement on June 8, 2026, without first engaging with him, despite having nearly a month since his final notice and more than a year since his initial notifications. Stevens views OpenAI's decision to proceed without any direct interaction as a sign of extreme disrespect. As a result, he has stated that he will not re-enter a quiet period unless it is part of a formal agreement. At the time of this recording, no settlement discussions or negotiations have been publicly confirmed. We can also report that the dead man's switch has not been activated, meaning Martin Stevens remains safe from both a physical and legal standpoint. We will provide updates as circumstances change.
Okay, let's unpack this. We are taking this stack of sources, which includes federal court rulings from early 2026, detailed demographic data, and legislative comparisons, to truly understand the real-world effects of demanding documentary proof of citizenship.
Yeah, and crucially, we are going to unpack the massive constitutional battle over Executive Order 14248.
Right, which is a battle that fundamentally questions who actually controls American elections.
But before we can possibly understand the massive legal battles happening in Washington, we first have to look at what actually happens on the ground when states demand this specific paperwork.
And to do that, our sources give us two major case studies. Kansas, which passed a DPOC law in 2013, and Arizona, which passed one way back in 2005.
What's fascinating here is that we don't have to guess what happens when these policies go live. These state laws essentially act as natural experiments.
Yeah, and the results analyzed by the Brennan Center provide a very clear mechanical look at the fallout. So let's examine Kansas.
Right. After their documentary proof requirement was implemented in 2013, between 8 and 14% of all new registrants were blocked.
Wow.
Yeah, that translates to tens of thousands of people whose voter registrations were just suspended or thrown out entirely.
I mean, I look at this data, and the analogy that keeps coming to my mind is that it is like needing a highly specific platinum VIP card just to enter your local public library.
That's a great way to put it.
You have a fundamental constitutional right to be inside, but the bouncer at the door is asking for a hyper-specific piece of plastic that you simply don't carry on you.
Exactly.
We hear so much about election integrity, but what stands out to you about who actually gets blocked by these laws? Because I initially assumed everyone just has a passport sitting in a desk drawer somewhere.
Right. A lot of people assume that, but then you look at the actual costs.
Well, yeah, they aren't cheap.
No. A first-time passport application is $55 or more, plus the cost of the photos.
And if you are living paycheck to paycheck, lacking that document is not an administrative error on your part. It is a severe financial barrier.
Precisely. And the evidence presented in the Kansas court cases show that almost all of those blocked registrants were, in fact, eligible U.S. citizens.
Wait, almost all of them?
Yes. The state could only produce evidence of fewer than 30 non-citizens who had even attempted to register.
Wow, less than 30.
Yeah. Meanwhile, 35,000 legitimate citizens were blocked just between 2013 and 2015.
That is a wild ratio.
And if we look at the national data, the systemic gaps become really obvious. Between 11 and 13 million American citizens lack these specific documents.
Because 59% of Americans do not own a passport.
Right. And if you don't have a passport, the backup option is usually a birth certificate.
But getting a replacement copy of a birth certificate from your home state, I mean, that can cost money and take up to 12 weeks to process.
Exactly. And that assumes a hospital even issued one when you were born.
Which brings up a crucial demographic point. This burden disproportionately hits specific groups of eligible voters, doesn't it?
It really does. It impacts low-income citizens who cannot afford the processing fees. It hits the elderly.
Especially African Americans born in the Jim Crow South, right?
Yes, where segregated hospital systems often meant births occurred at home with midwives, which resulted in delayed or non-existent official state birth certificates.
It also heavily impacts Native Americans born on reservations who may never have received formal state documentation.
Exactly.
And it creates a massive headache for married women.
Oh, absolutely.
If a woman changes her name when she gets married, her current legal name no longer matches the maiden name printed on her original birth certificate.
Right. So to the state bureaucracy, Mary Smith and Mary Jones look like two entirely different people.
Even if she has been voting at the exact same precinct for 30 years, she would have to produce her birth certificate plus a legal marriage license just to prove the chain of identity.
There's a lot of hoops to jump through. And Arizona saw the exact same mechanical breakdown.
Really? Same thing there.
Yeah. In Maricopa County alone, an estimated 17,000 eligible citizens had their registration forms literally thrown in boxes and set aside because they lacked the right paperwork.
Just sitting in boxes.
Across Arizona's most populous counties, 1 in 3 applicants was rejected in the first 5 months of the law.
So if paper documents create this massive, expensive physical bottleneck on the ground and the state struggled to manage it, I have to assume Washington tried to standardize this.
They did.
Here's where it gets really interesting. Congress actually tackled this issue with the National Voter Registration Act of 1993.
Often called the motor voter law.
Right. When they were debating that bill, they explicitly considered adding a strict citizenship document requirement. But they intentionally rejected it.
Yeah, they realized that requiring physical documents would mechanically destroy mail-in voter registration drives.
Because you can't just expect people to have that stuff on them at the grocery store.
Exactly. Imagine organizations like the League of Women Voters setting up a registration table outside a grocery store or like a college campus.
You cannot register people if they are required to somehow photocopy their passport right next to the shopping carts and attach it to the form.
It just doesn't work. So instead of demanding physical documents, Congress required a simple attestation.
You just sign a standard federal form under penalty of perjury swearing you are a U.S. citizen.
And that specific congressional decision became the crux of a major Supreme Court case in 2013, Arizona v. Intertribal Council of Arizona.
What did the court say?
The Supreme Court ruled that because Congress has the ultimate constitutional authority over federal election procedures, states cannot demand extra documentary proof from voters who are using that standard federal mail-in form.
So Congress decided the perjury attestation was sufficient and the states were barred from unilaterally adding a passport requirement on top of it.
Exactly.
But playing devil's advocate for a moment here, it is 2026. We live in a highly digitized age. If carrying around physical paper birth certificates is too hard and Congress protected the mail-in forms, why not just bypass the paper entirely?
You mean using a digital system?
Yeah, why not just ping a massive federal government database the moment someone registers to verify their citizenship?
Well, if we connect this to the bigger picture, the digital database solution sounds perfectly logical until you look at how federal databases are actually constructed mechanically.
Okay, how are they constructed?
Our sources highlight a specific Fox News report analyzing the SAE database.
SVE, meaning Systematic Alien Verification for Entitlements. And it is run by the Department of Homeland Security.
Right. And people hear a name like that and naturally assume it is a giant master registry of every single U.S. citizen.
I mean, I would assume that.
But the United States simply does not have a national master registry of its citizens. The SAVE database is structurally designed to track immigrants.
So it's not a citizen database at all.
No, it is an incomplete list of non-citizens who have legally interacted with the federal government, plus some undocumented individuals who have come into contact with authorities.
Wow. Relying on the SAVE database to verify all U.S. citizens is like trying to use a list of people who do not have library cards to figure out who checked out a specific book.
That is a perfect way to look at it. It is looking at the entirely wrong data set.
How does that even work technically?
Mechanically, a database query requires a matching primary identifier, like an alien registration number. Natural-born U.S. citizens do not possess those numbers.
Of course not.
So if a state election official runs a natural-born citizen from Ohio through the SAVE system, the computer does not return a green check mark that says confirmed citizen.
It probably just returns an error.
Exactly. It returns an error or a blank file. An untrained poll worker sees no record found and interprets that as an invalid or illegal voter.
When in reality, the person just isn't in the database because they never had to apply for an immigration visa.
Precisely.
So the paper documents cause massive bottlenecks for vulnerable citizens. Congress explicitly rejected requiring them. The Supreme Court backed Congress, and the digital databases are mechanically incapable of solving the problem.
That is the chain of failures, yes.
And that brings us to the absolute powder keg in our sources. Since Congress established the rules and the databases are inadequate, what happens when the president decides to bypass the legislative branch entirely to force the issue?
This is where we enter the constitutional showdown over Executive Order 14248.
Right, issued in March 2025 by President Trump.
Yes, and this executive order directed federal agencies to demand documentary proof of citizenship on that federal form we just talked about.
And also on the military overseas form, the FPCA.
Exactly.
I mean, this feels like a CEO trying to completely rewrite the company's foundational bylaws without asking the board of directors. Can the president actually do that?
This raises an important question, and it's perhaps the most fundamental question in American civics: the separation of powers.
Okay.
To answer it, our sources dive into the permanent injunctions issued by two federal judges, Judge Collar-Cotelli in D.C. in January 2026 and Judge Casper in Boston.
And both judges looked at the mechanics of this executive order and struck it down.
Yes, but their reasoning wasn't just about whether the policy of proving citizenship was a good or bad idea.
It was strictly about who possesses the mechanical power to make that policy.
Exactly. They grounded their rulings entirely in the text of the Constitution, specifically focusing on two clauses: the Elections Clause and the Voter Qualifications Clause.
Let's break those down.
Sure. The Elections Clause, found in Article 1, Section 4, dictates that the times, places, and manner of holding elections shall be prescribed by the state legislatures.
But that Congress may at any time make or alter those regulations.
Correct. And the Voter Qualifications Clause similarly assigns the power to determine who is qualified to vote to the states.
So the Constitution explicitly names Congress and the states, but where does the president fit into that workflow?
They don't. The framers of the Constitution deliberately gave zero role to the president or the executive branch regarding federal election procedures.
Zero role. That is a pretty absolute term in constitutional law.
It is.
Why were the framers so strict about keeping the president out of the machinery of elections?
It was a conscious, mechanical safeguard. The framers were terrified of autocracy.
Right, because of the king.
Exactly. They reasoned that if a single executive, the president, had the power to dictate how elections were run, who could vote, or what specific paperwork was required to access the ballot, that individual could easily manipulate the vote.
To ensure they simply stayed in power forever.
Exactly. By vesting that power in the decentralized state legislatures and a multi-member Congress, it diffuses the risk.
That makes a lot of sense.
So when the president issued Executive Order 14248 demanding new proof of citizenship, the federal judges permanently enjoined it because the president clearly exceeded his constitutional authority.
They acted to enforce the separation of powers.
Yes.
So the president cannot just mandate an election rule with a pen stroke, which means if the judicial branch firmly declares that the executive branch cannot unilaterally change election law, the battle inherently shifts back to the legislative branch.
Where the power actually belongs under the Constitution.
Right. And that brings us to the SEOE Act.
H.R. 22 and S-128. This is the legislative alternative pushed by Republicans that successfully passed the House but stalled in the Senate.
So what does this all mean? How does a piece of legislation like the SEV Act mechanically differ from the executive order that got blocked by the judges?
Well, we can look at the analysis from the Campaign Legal Center to see the mechanical differences.
Okay.
While the executive order tried to target specific federal forms, which the court said the president lacked the authority to do, the SAVE Act is a proposed act of Congress.
Therefore, it has the constitutional authority to alter the rules.
Right. It would mandate documentary proof of citizenship for all federal registrations, regardless of what form you use.
Wait, earlier we talked about how Congress in 1993 realized that requiring physical documents would destroy mail-in voter registration.
Yeah, we did.
If the SAVE Act applies to all registrations, doesn't that effectively kill mail-in drives entirely? You obviously cannot put your original physical passport in the mail.
According to the Campaign Legal Center's analysis, it would effectively end mail-in voter registration as we know it.
Wow.
Because if you apply by mail, the SAVE Act would require you to still present your physical citizenship documents in person to an election official before the deadline.
So you could no longer just fill out a form and drop it in the mailbox.
It mandates an in-person physical verification step.
That completely changes the mechanical landscape of how millions of people get on the voter rolls.
It really does.
Let's talk about the acceptable documents. Are they the same as the ones demanded by the executive order? I see Real ID mentioned frequently in the sources. What makes a Real ID different from a standard driver's license?
It is similar, but with key legislative distinctions. Under the SAVE Act, acceptable documents would include a U.S. passport or a Real ID that specifically indicates citizenship.
How does a Real ID do that mechanically?
Well, mechanically, a Real ID requires the state DMV to physically inspect and scan proofs of identity and legal U.S. presence before issuing the card with that gold star on it.
Okay, I see. So the SAVE Act effectively offloads the citizenship verification burden to the DMV.
Precisely. And interestingly, the analysis notes that tribal IDs would not be sufficient under the executive order, even if accompanied by additional proof.
But what about the SAVE Act?
The legislative debate around the SAVE Act involves intense negotiations over which specific state and tribal documents qualify.
So it is essentially a different branch of government trying to build the same wall, but using their constitutionally assigned tools to do it.
That's a great summary.
Well, to wrap up this deep dive, we have seen how requiring documentary proof of citizenship, as tested in ground-level natural experiment,
Yeah, a bottleneck that blocks tens of thousands of legitimate, eligible voters.
simply because they do not have the right, expensive, or hard-to-get paperwork, often due to historical or financial barriers. And we explored how digital databases like SAVE fail mechanically because they are designed to track visas, not natural-born citizens.
That's clear.
And crucially, we unpacked how the federal courts drew a hard constitutional line in the sand regarding Executive Order 14248. The president cannot rewrite election laws.
That power belongs exclusively to Congress and the states.
Whether you are prepping for a meeting on civics, studying constitutional law, or just trying to stay informed, understanding this mechanical separation of powers is critical to knowing how your rights are protected against executive overreach.
As we consider where this goes next, especially with legislation like the SAVE Act still hovering in the background, I want to leave you with one final thought to consider that builds on our sources.
What's that?
Think about the military voters we mentioned earlier, the ones using the federal postcard application to vote from overseas.
Right, the FPCA.
If Congress eventually passes a strict documentary proof of citizenship law, like the SAVE Act, how exactly do we balance election security with the sheer physical reality of an 18-year-old soldier stationed in a remote combat zone trying to securely mail a physical photocopy of their passport just to cast a ballot? It is a logistical paradox that goes right to the heart of what it means to participate in a democracy.
If you found this episode valuable, please like, subscribe, share, follow, and turn on notifications. It helps us continue bringing you content like this and ensures you never miss future releases.